Good evening, ladies and gentlemen, and welcome to KNDI Artery Live. So today we're going to discuss a very important topic that affects professionals, students, and stakeholders of Kenya Nutritionists and Dietitians Institute, the regulatory body of nutritionists and dietitians in Kenya, CAP 253B. We have noticed that a lot of the professionals and students have heard about CAP 253B, but they do not understand what it is, why it was instituted, and its mandate. So today, we will have Dr. David Okeyo, the Chief Executive of Kenya Nutritionists and Dietitians Institute, who will tell us more about CAP 253B. Welcome, Dr.
Thank you. Good evening, Laura. And of course, let me tell the viewers, good evening too. If you are online, please get tuned very well today. We have chosen a topic today which is in my heart. I think this is why we are here.
Yes.
And I've heard you say it very well, that CAP 253B. But let me, first of all, give my stake when it comes to nutritionist profession and dietitians professionals. In the recent past, we have had a lot of issues to do with the lack of inadequacy in knowledge, particularly when we are conducting our oral examinations for graduates from universities, particularly those who graduate from our accredited institutions. And one of the things we have realized is that when they come here for oral examination before they are admitted into the profession, they actually embarrass us. Actually, this is one of the things I wouldn't want to say, but 70% of those graduates normally fail legal framework as an assessment domain. And it has made us to know that probably our teachers or lecturers in the universities and colleges are not giving this a priority, because they are training professionals who will surely be registered under the Act, but they don't actually go through the Act so that the professionals can be acquainted with the provisions. So I think if we start from there, that is the basis and the problem that we want to address today. Now, you know, the laws of Kenya are many.
Yes.
And all laws are passed by Parliament. This act was passed by Parliament in 2007, and it was ascended to by His Excellency, the late Mwai Kibaki. It began operation in 2008.
Okay.
And we had the first council gazetted in 2010. So which means there was a phase where there were caretaker committee that was implementing this from the Ministry of Health. Now, it is unfortunate that up to now, 15 years plus later, our nutritionists who are in practice and also those who are training, majority of them are not able to cite the Act. You'll find somebody can cite Public Health Act, CAP 242, but they cannot cite their own Act. So when you ask them, what is the name of the Act under which you are registered? Yes. Then they start fumbling. Now today, I want to tell the viewers that it is good to get this knowledge very clear. That the first page of this Act gives the citation. Yes. And the citation is very clear. The Nutritionists and Dietitians Act, number 18 of 2007. And in the Kenyan law listing, it is found under CAP 253B, or we can say Chapter 253B. So any nutritionist that is trained must know how to cite the Act by name. So we have had people call it KNDI Act. Another one is calling Nutritionist Act. Another one say Dietitians Act. But the Act is very simple. The Nutritionist and Dietitians Act, number 18 of 2007. And it is CAP 253B. Now, this Act has been amended once within the Health Laws Amendment in 2019 And now we have a revised version, which is published by the National Council for Law Reporting with the authority of the Attorney General. So this is one of the laws of the land, that anyone who violates commits a crime. So we will be talking about this, and I want to believe that is why we are here today.
Yes.
And today it is very serious because we are talking about something that can take you to jail or can make you to become the best professional so far if you are in nutrition and dietetics. Thank you.
Thank you. So could you kindly proceed and explain to us what is CAP 253B? Because you've clearly told us how it has come into existence. What is key in it?
The most important thing, first of all, I would want to tell, particularly the Kenyan public,
Yes.
who are the key beneficiaries and the primary beneficiary of this Act's provision.
Yes.
And our professionals that are also primary beneficiaries. And of course, the government that is a tertiary beneficiary. And of course, the implementers in service delivery ends that are secondary beneficiaries of the Act. This is the only Act of Parliament regulating the profession of nutrition and dietetics worldwide. So you cannot find any country in the world that has an Act of Parliament which regulates the profession of nutrition and dietetics. And it is something that we really have to appreciate, the fact that the nutritionists that went ahead of us did very well to ensure that this Act goes through Parliament. Thank be to Professor Julia that spearheaded the process alongside other nutritionists. Now, this Act was brought in as a self-regulating Act. In fact, the Nutritionists and Dietitians Act number 18 of 2007, even though it classifies our position as part of the regulatory authorities under Ministry of Health, State Department for Public Health and Professional Standards by executive order, it is one of the acts that is different from all the other acts. And it was not by design. It was for a purpose. And I remember when I came into the profession and registered, the first question I asked was how this act is executed when it comes to implementation. And one of the things I learned when I was in the university was that the then Cabinet Secretary, Beth Mugo,
Yes.
together with the counterpart, Professor Nyang' Nyong'o, who were leading the Ministry of Health at that particular point in time, was very clear that this act was brought as a self-regulating act. Now, when you talk about self-regulation, it is very simple. The professionals are fully mandated to regulate themselves and set standards for the profession, and also set standards for training, and set standards for themselves as practitioners. Which means that this act allows the professionals to tell themselves, this is how we want nutrition to be practiced in this country, Kenya. And so Beth Mugo, when she was instituting this and giving the first interim committee that was spearheading this process under the Ministry of Health, was very clear that within the shortest time possible, there should have been a council in place, which was done. But one thing that she said is that nobody who is working in government as a civil servant should be part of the implementing team when it comes to council matters in this act.
Okay.
So it only gave one position, which is the Director of Nutrition Services, that is by default as an officer, should be part of this act, and the Director General, that time was DMS, now it is Director General, that should also be part of this act. And they were supposed to be the conduit between the Ministry of Health and the professionals.
Okay.
So that any information that would come from KNDI, the institute which is created by the act, would then be taken to the ministry, and the ministry would give policy direction through the same group during council proceedings, which has not been followed to date. Now, The executive orders came and classified this institute created by an act, by this act, under State Department for Public Health and Professional Standards. And we have no problem with that. It's a very good initiative that the president himself decided to position the institute with and give us the direction for the act in terms of business. Now, one thing I would want to say is that an executive order places an institution for business purpose, not for control. So we have had a lot of problems when it comes to the person taking authority, that who is more supreme when it comes to the implementation. And we know that by default from the act, the cabinet secretary is the oversighting office. And we also know that the ministry has representatives in the council and the professionals. But then you'll find that the ministry has been thinking that this act is supposed to be controlled by the cabinet secretary. It is a self-regulating act where the professionals themselves decide on who the chair is, and also decide on the representation from different structures of the profession, like training institutions, private practice, and of course we can talk about things like representation for different committees in the council, which is also well specified. So one of the things that I would want to bring on board, first of all, before we get into the detail, is that this Act of Parliament was brought on board to provide for training, also registration and licensing of nutritionists and dietitians. Also, as a mandate, which the professionals must know, was to provide for regulation of standards and then the practice of the profession. Now, people have been thinking that the Act was only meant for professionals to be regulated. Just like when you go to the Medical and Practitioners Board, it is purely for regulation of medical doctors. If you go to the Nursing Council, it's purely for regulation of nurses.
Yes.
And the same to Public Health Officers and Technicians Board, and among others.
Yes.
Now, this one was meant to regulate the professionals as well as the profession. And so when we talk of setting standards and practice for the profession, it means that it sets up the basis and the structure for standardized programs in nutrition and dietetics, which means that all matters of nutrition and dietetics, whether it is guideline or policy, must give this act a hearing and must ensure that they align to the standard set by the profession. Now, there is also the element of ensuring effective participation in matters relating to nutrition and dietetics, which means those sensitive areas and specific areas of nutrition where people engage in, they are supposed to actively participate and give their opinion, and then connected purposes, which means that this act allows the professionals of nutritionists and dietitians not to be ignored in any matter related to nutrition in Kenya, whether being implemented by an international organization or an NGO or a US body or the ministries, not only Ministry of Health, but Ministry of Agriculture. And I can give you an example. When the Ministry of Agriculture was launching their training package, they had to come here for accreditation of that training standards for the professionals to put it into use. But I know there are other ministries that are ignoring the institute and they go ahead implementing their own guidelines without making reference to the institute, which is something that they must know today, that this act gives that provision for setting standards. And this one can be expanded to the functions. And the functions here means that functions of the council, which is the governing body. So you'll see in the structure, we have a council, and the council is allowed to form not less than 4 committees. And some committees are statutory, like accreditation and disciplinary, while others can be formed as ad hoc by the council itself. And now the council is given functions to do. And some of those functions are very clear in section 6, which we want the professionals to read.
Okay.
And I would just want to say the first 3 functions is purely on setting standards for the professionals and the profession.
Okay.
And then we have the training. Then we have now the service end. Now, the good news about this act, which the professionals should know,
Yes.
that makes it unique. Today, we will have to take a bit of time, is the fact that our act was given the mandate to perform both regulatory and service functions.
Okay.
So when you look at section 6, from paragraph A to D, those are regulatory functions. From E to J, those are service-oriented functions. And that is why Parliament, in their own wisdom, decided that this act is a non-exchequer act, where there should be no allocation from consolidated funds through exchequer. And that is through National Treasury. So with the self-regulation, the Parliament gave this act power to look for their own resources, to run government functions. So it is the only act that allows the professionals to use their own money to do government work, unlike any other act. And that is why I was very happy when the executive decided that all regulatory boards should not be funded through exchequer. Even though some of our friends were crying because they depend on exchequer for them to run, we were celebrating. And they went around again to go and look for how they can get exchequer money. But I said, no, we can look for funds through public-private partnership, through government partnership, and of course, through fees that we collect, and through service delivery charges when we offer direct or indirect services to the public and private organizations. And then we can also get direct grants from multilateral and bilateral. And so the council has come with wisdom to separate the functions. The service functions are running with the managing partner, and then the regulatory ones remains with the council, but the council still have full authority. So that self-regulation is what I'm trying to explain, so that people should not have problems when it comes to the fact that we are not on exchequer and still they want to take control when it comes to the matters of running this institution. Now, I would want to jump and go straight to the AGM, which is in the provision of the Act. I know you have some questions, but let me go there first and say exactly what self-regulation means. You see, when you have the institute, it's made up of professionals. So the professionals are the owners of the institute, and they have a CEO. Yes. Now, government and Parliament gave the CEO a governing body called the Council within the same Act under Section 5. So the Council is the governing body, together with the committees that do technical work to help the Council, and the CEO runs the institute, having been appointed by the Council. Now, during AGM, all professionals are supposed to convene annually so that they receive audited accounts for the running of the institute and also give authority to spend. Now, some people came somewhere and tried to mess up this act by including the Auditor General in the act to be auditing the funds of professionals, which are called private public funds. So I'm interpreting that component to mean the professionals have already met their statutory criteria with the KRA and other deductions. Yes. Now the money they have received, they're now subscribing to the institute. That money is not public money. It's not from consolidated funds. It is coming from the members of the public, but as private money. Okay. So the Auditor General has no authority at all to audit it. Because if they audit it, then they will be forced to subject that audit report to the AGM. So the Auditor General cannot be subject to the AGM of a professional body. Their work is to audit public funds from consolidated funds and report to the public account committees in Parliament. Okay. So that was a confusion that was brought by the Ministry of Health when they attempted to amend this without looking at the content of the Act. And it has brought many problems. So sometimes people think that we are defiant, but we are not defiant. We have accountability mechanism that the Act itself brought on board, where the professionals themselves run the institute's finances based on the legal provisions that are in the Act. And that is under section, I can say that for our professionals, they should read it from section 30, let me go there, from section 27, which talks about the financial provisions and the funds of the institute, where somebody sneaked in Auditor General from nowhere without understanding the role of the Auditor General. Okay. So I wanted to bring on board on that so that now we say the checks and balances are brought on board through professional AGM, who also appoint their own auditors during such AGMs that reports to them on how the institute has worked with their funds, and then they give authority to spend. Which means if we don't conduct AGM, like in this case where the cabinet secretary has delayed with the gazettement of the council, then we are actually violating the provisions of the law. And so the AGM should be called so that they can see how the institute is managing their funds. So up to that point, I think I've dwelled so much on self-regulation. So we can go business with the other questions.
Okay, thank you so much. So before we proceed to the next questions, we're going to take a short break. We have an important announcement to make.
Just go ahead.
So we invite all researchers, practitioners, students, and professionals to participate in the upcoming scientific conference, which will be held in November from 9th to 13th. And the theme of this conference will be Excellence in Nutrition Practice, Science, Innovation, and Impact. So we have opened a call for abstracts. So as it is being displayed on your screen, you could proceed to our website, KNDI conference, and submit your details and abstracts. You'll be able also to get important updates on the conference. So thank you, we are back. So Dr. Okeyo, we've clearly understood what self-regulation is. Why is it then important for CAP 253B to be followed strictly in order to improve the growth and governance of this profession, nutrition and dietetics?
Thank you, Laura. And just before that, I would also want to reaffirm the fact that conference series that ATRI program under Research and Innovation Pillar normally organizes is, I'm glad that I'm part of it as the conference director, is one of the key mandates that the Act gave the Institute. And so it has been taken to the managing partner, where now they can have full expertise to run that service end. And so we are very glad that we want to invite everybody this time around. We are going to host the conference in Kisii University in partnership, having been accredited. We only work with people who have been accredited. So they have accepted to host us, and we want everybody to come and showcase what they have in exhibitions. We also want to come people to come with the learning labs and of course exhibitions in terms of the products and every other aspect. We will also have KNDI, that is all students from all universities are supposed to convene there for purposes of science and of course symposium and related services. Thank you very much.
Thank you.
Now, you are asking, why should it be followed strictly?
Yes.
Let me be honest. Any law of the land must be followed to the letter. Now, our president, His Excellency, Dr. William Ruto, when he was taking oath as a president, he has been very clear that he would protect the Kenyan Constitution as it is now, the 2010. And likewise, he also expects all Kenyans to adhere to the constitutional provisions as well as ensuring that they adhere to the laws of Kenya. We expect that. Now, we have three arms of government. We know that.
Yes.
We have parliament that their work is to ensure that they institute relevant laws which are needed for the country to move on We also have the judiciary that interprets the laws that have been made. And then we have the executive that now gives service delivery to Kenyans as they promised, because that's a political end. Now, the president expects everyone to adhere to the laws. The judiciary takes charge to make judgment when people or disobey laws. And that such judgment can lead to criminal offenses, and people can be taken to jail or fined, depending on which law they are violated.
Okay.
Parliament expects that the laws are implemented the way they prescribed it, and so they can easily call any institution like KNDI or any other that has been created by law and ask them questions concerning the implementation of their law. Now, one thing I want to make clear here is that Parliament, after creating the law, have no authority at all to mess up with the implementation of the law, except when they amend the law. So it needs to be very clear on that.
Okay.
And so sometimes you have seen cases whereby Parliament sometimes try to force people to implement things, to agree on how to implement a law. And sometimes when you agree, the judges will not allow you to agree, because certain laws are very strict on the implementation.
Okay.
So you cannot come up with things called harmonization. You cannot harmonize laws that have already been passed. You can only amend. And if there is collaboration, then that can be on agreement between two parties. But there's no way you can harmonize laws. So any attempt to violate any provision of the Act is chargeable under criminal offense if properly interpreted by the judge. And so this law, like any other law, must be followed. And I want to be very candid that everybody should obey this law, including the executive. Because if an executive violates this law, then they are criminals, if interpreted by the judge. If I violate this law, then I can be sued. That's why the provisions of the Act says it says that this Act will create a body called KNDI, that is Kenya Nutritionists and Dieticians Institute, as a body corporate that can sue and can be sued. So the provisions of this Act can allow for suing in High Court. The institution itself, KNDI, can also be sued. And so therefore, the professionals must adhere to the provisions of the Act. The members of the public must also adhere to the provisions of the Act. The executive must adhere to the provisions of the Act. So for the professionals, there are various sections dealing with the practice of nutrition and dietetics, and particularly areas of disciplinary actions to be taken against any malpractice under Section 25. And also areas to do with the accreditation of training institutions, and also admission into the profession, conditions to be met. Okay. And then miscellaneous provisions on violations of or offenses related to the practice. For example, if you're practicing without a license and you are qualified, there is a provision under which you can be charged in the court of law. The same applies to when you're training without a license or approval by the institute. Again, there are provisions that can make you to be charged in the court of law. And also when you are not trained and you are practicing using the name nutritionist or dietitian, there are provisions for dealing with such offenses. So this law allows for a charge sheet if there is any violation by the institute. Okay. And so at any given time, the institute can look for police and arrest someone who is engaging in malpractice against the law. The Act also gives the provision on how the executives relate with the council and the institute itself. And so it is very important to tell the professionals, for example, that this Act has every provision for them. It has every provision for the executive oversight body, that is the office of the cabinet secretary. It is very clear on the role of the cabinet secretary. And any attempt to manipulate the Act sections is also violating the provisions and therefore can be sued, can be put before a judge for interpretation. And you know very well that professionals can do that. If the CEO violates the provisions of the act, the professionals can sue him as a person and also the institute for not taking responsibility, and even go to the extent of suing the council. This act can sue the cabinet secretary. Like in the recent past, we have seen a case where a professional has sued the cabinet secretary for not gazetting the council. And the court has awarded order of mandamus as a prayer, for which we really find it difficult to explain why someone in an office is not able to do the work that the provisions are very clear. And of course, now we go to the extent of violating even the Constitution, for which we swore to protect as executive, and violating other acts like the Leadership Act. You get that?
Yes.
Fair Administration Act, and many others, just because of our position. So this act, actually, the provisions must be followed by everyone. So it is a law of the land. Okay. And there is no one in Kenya that is above the law. It's only the president that has immunity for the period when he is in the office. The rest are subject to the provisions of laws of Kenya. And so the professionals are advised to pick this law, download it, it is everywhere, and read the provisions from page 1 to the last page to acquaint themselves with the content. And that's why we always assess it during oral examinations. And where a student fails, we refer them back to go and download and read the content and examine them again, so that they don't embarrass the profession. So all professionals, I would advise, let them adhere to the provisions of the law. And anytime any provision is violated, it is them in self-regulation that should report the matter, either directly to the executive and make queries, or who are doing oversight, that is, or just go to High Court and file a case. And even them themselves, if they violate, somebody will sue them. They will be deregistered. And where possible, if they engage in criminal activities, they will be sued. So the act is very important. And I'm very happy that it's bringing sanity when it comes to the practice of nutrition and dietetics in the country. And right now, we know very well that the profession has gained visibility because of the existence of this act. And the Institute is really implementing the act by ensuring that they are confined to the provisions of the law, to the letter, without any fear of or favor. And in this case, there is no even any element of intimidation that can stop the Institute if they align to the provisions of the act. So I would want to probably make the public comfortable by saying that the law itself protects Kenyans from any form of malpractice in nutrition and dietetics, and also allows them to have access to well-trained and qualified professionals that are licensed under this act. And those are the only ones that can protect their well-being and nutritional status in the country. Thank you.
So as we come to conclusion, what would be your final message regarding CAP 253B and the future of nutrition and dietetics practice in Kenya?
The future of nutrition and dietetics is bright. I know that is a very common English sentence. Everybody always wants to say that. And the existence of this act is super, because we brag in the entire world as the only one with the act. I know a country like Zambia recently got an act of parliament dealing on matters of nutrition, but it's purely a service act. It's not a regulatory act. It is mainly looking at nutrition service delivery and food security. But our act actually is regulating the profession, setting standards. And now it's even setting pace for countries outside Kenya, the Africa. Now, one message I would want to pass is that everybody who interacts with this act, and probably interact with the institute that the act created, must understand this law and the provisions of the law. And most important, the legal advisors of oversight bodies, as well as the legal advisors of ministries. They should actually read these acts and understand, including Parliament, because we have discovered that even Parliament don't understand their own act. members of parliament, that is. So the professionals have obligation, to ensure that they acquaint themselves with this law from day one of their admission into the university. The first course, Introduction to Nutrition and Dietetics, has legal framework properly described as one of the content of that particular course, where they are taught about the Nutritionists and Dietitians Act, and properly taught so that they can understand the profession where they are and how they will be registered. It is unfortunate that when they graduate, they still cannot understand or even cite the act itself. It is also coming as a concern to us that even mentioning the mandate is a problem for those who have graduated, yet they have gone through this program all through. My advice is that they better get it now. Let them go through it, read it, understand the content, so that they can stand firm to protect the act. The act itself can protect the institute functions. The act itself can protect the professionals. And the professionals can also protect their act by ensuring that no one infringe into the provisions that are provided as malpractice if they're not properly trained and they are not covered by the act itself. So this act creates an environment where nutritionists will now deliver their services without interference. And so they should be happy that they have an act to bring sanity. They should be happy that they want to deliver services that are recognized in the country because of the act itself. And so this legal act covers everybody. So everyone should respect it until the day when it is repealed. Thank you.
Thank you. We have come to the end of our session today, and it is very clear that every profession should be able to understand the legal framework and the act that governs their profession. From your host, Wang'ara Laura, see you then.